Each side will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. Let me know when you get started. I'm keeping track of the clock today, and I will let you know when you're getting close to your rebuttal time. The case that will be heard this morning is State of Ohio versus Darrell Grantham. We are ready to proceed when you are.
Great. Good morning, Your Honors. May it please the court, Giovanna Bremke on behalf of Mr. Grantham. We are here today with 3 assignments of error. The first being that Mr. Grantham was denied his due process rights as the result of a vindictive sentence because of his choice to go to trial as opposed to take a plea offer. And then
I'm going to stop you. I'm going to stop you there real quick, Ms. Bremke. 2 things. One is, would you like to reserve any time for rebuttal?
5 minutes. Thank
okay.
you.
And number 2, I can hear you, but you're kind of faint, so please keep your voice up.
Oh, okay. So the second and third assignments of error are the sufficiency and the manifest weight arguments. Starting with the vindictiveness argument, Mr. Grantham, the case was pending for a long period of time in the trial court, and at one point he had withdrawn his, he had entered a plea of guilty, and then to all 8 counts. There was originally 8 counts, and then he withdrew his plea because there was talk of a new case, new allegations, and those never came to fruition. The trial court judge, he ends up going to a jury trial. He's found not guilty of all but 2 of the counts, and the 2 that he was found guilty of were, I believe, the lowest degree of all of them. So there were rape charges that he was found not guilty of, unlawful sexual conduct with a minor, all of the very serious charges he was found not guilty of, and then he was found guilty of just 2 of those charges, tampering with evidence and importuning, which are both, the tampering is an F3 and the importuning is an F5. He was sentenced to 24 months, and there was quite a bit in the sentencing hearing, and I'm going to point to the transcript, page 447. The sentencing hearing, the attorney raises the issue that he was previously offered probation on more serious charges, and that it would be a punishment if he was sentenced to a term of incarceration after he was had a deal for probation based on new evidence that never came to fruition. The trial court acknowledges that he understood that there was an offer for probation, and that likely Mr. Grantham wasn't prepared to go to prison that day. On that same page in the transcript, the trial court judge does acknowledge that and says that, that he would actually give him time to report to prison because he probably wasn't prepared for that. Essentially, Mr. Grantham's decision to go to trial was resulted in 2 years of incarceration, and he could have had a deal for probation, but the judge's vindictive sentencing resulted in additional incarceration. The second assignment of error is the tampering with evidence, and there's a tampering with evidence and the importuning. The sufficiency argument for the tampering goes with 292912A1. That's the code section for tampering, and it says specifically that no person knowing that an official proceeding or investigation is in progress, that they hinder that investigation or tamper with the evidence. So the state failed to prove any evidence that these messages were deleted after Mr. Grantham knew that the investigation was pending. So there's actually 2, there's a Detective Homoki on transcript page 277. He specifically asked, do you know when these text messages were deleted? And he says, no, he couldn't tell. Then they had transcript page 303. they have Detective Sumter. He testifies, he does the Celebrate software for the text messages, and he testifies that he's essentially their expert in the phone technology area for the department. And he says that there's no way in the Celebrate software, and he, has used this software time and time again, that there's no way that he could tell when these messages were deleted. So there's no evidence that Mr. Grantham, deleted the messages knowing that an investigation was pending. And it is important to note that there was quite a bit of time, I believe in excess of a month, between the time where these allegations were alleged to have occurred and the time when there was the police investigation. So there could have been a time where there was a deletion of messages just as a routine and not as a result of the fact that there was an investigation pending. For the importuning, this section is 2907.07D1, and that had the state failed to prove that there was any solicitation. So there was 2 messages that essentially were at question here. And one of them was come down in the morning when she leaves. Now there's multiple words spelled wrong, and the state focuses on the spelling of the come in that text messages, and it says that because of that spelling, it was sexual in nature and it was a solicitation. But these text messages in themselves are not soliciting in any way, and therefore don't meet the element of solicitation in that code section.
Counsel, was there testimony in the record that your client confessed to the sexual nature of these messages?
I believe that the record reflects that he admits to sending messages, but that I think that he may have said that, I don't know specifically to these text messages. He said that at one point they were flirting, but I don't know if that was the sexual nature of it. They were essentially living together. He lived with the aunt of this young lady, and there was other messages. It wouldn't be unusual to say, come downstairs or whatnot. They did live in the same household more or less. He was there multiple days a week. The manifest weight argument, the third assignment of error, deals with the same, there's, only the 2 charges that, the 2 convictions and the tampering. And again, that there was, the state failed to meet their burden of persuasion as far as when these text messages were sent. And there's just really no evidence at all. Even if you view this in light most favorable to the state, there's really no evidence that these text messages were deleted after he knew there was an investigation pending. And like I said, it wasn't as though these allegations occurred and Mr. Grantham knew right away that they were going to the police station. There was about a month in between where there could have been a routine deletion of the messages. There was no admission as to, that these were deleted because of there was an investigation pending. And even their expert says that there's no way he could tell when these were deleted. So there's essentially just no evidence that there was any tampering that happened.
When you say no evidence, do you mean no direct evidence or no? There was circumstantial evidence, wasn't there? The fact that the last message that shows up on the phone is, can you hear me still? Because my battery's.
I can hear you.
Okay. Was on the date that the aunt had made the phone call, for instance. Trying to think of some of the other, there was circumstantial evidence, wasn't there?
Again, the fact that I think that's what the state had argued, that the aunt had made the call and there was a deletion at that point. But there again there's no that is really a leap to say that was the reason. There was no one in that department that can say when those text messages were deleted. I don't believe those were the only text messages deleted. And there was testimony that there were multiple people using that cell phone, including the young lady who made the allegations. So he wasn't the only one to use that phone, that they had gone on a vacation in between, and that she was using that phone to take photos on that vacation, and other people in the family were as well. So even if there was a deletion, really, there was absolutely nothing that said, there was no testimony that my client had deleted them.
Thank you.
And counsel, you're just now coming up to that 5 minutes.
I would reserve the rest of my time. Thank you.
Okay.
Judge, before we hear from counsel, can I go get my charger and plug in, because we went blank there and I had a notice that I'm running low. So just to
Sure.
if you don't mind, I apologize.
Could you hear me better when I?
Yes,
Okay.
yes.
I had done a test run with the Supreme Court and they made me adjust my settings, and I don't think it's favorable actually. So, well, maybe I'll change them back. I don't know.
Okay, can everybody hear me?
Yes, we can.
Yes.
All right, thank you for your patience. All right, I'm all set, Judge.
Can I just ask a quick question since you have a little bit? I just want to know, there was a PSI done, and is it in the record?
There was a PSI, and yes, I did. I supplemented in the record.
Okay, Ms. Poprocki?
Okay. Good morning, Your Honors. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the state of Ohio. And in response to Grantham's first assignment of error, the state submits that the trial court properly sentenced him to a term of imprisonment after he chose to withdraw his plea and proceed to trial, and that it did not vindictively sentence him in doing so. Here, Grantham failed to clearly and convincingly demonstrate that the trial court imposed a stricter sentence upon him based on his decision to withdraw his guilty plea and proceed to trial. Instead, the trial court properly imposed Grantham's sentence and made its decision to do so with more information at its disposal following a jury trial. In fact, this court has adopted the view that there are legitimate reasons why a trial court may sentence a defendant more harshly after a trial on the merits than it may after a guilty plea. For example, after trials, trial courts know more details about the facts of the case, circumstances surrounding the events, and victim impact than it would following a guilty plea. Here, many of Grantham's allegations which would suggest that the trial court imposed a vindictive sentence upon him are belied by the record. And I think it's important to look a little bit more deeply at the procedural history here and look at what proceeded before Grantham's sentence was imposed. Grantham did initially plea to an amended indictment here, which dismissed the 3 first counts, which were of forcible rape. And contrary to his assertions in his brief, there was no original probation plea agreement between Grantham and the state at the time of his initial guilty plea. In fact, at the time of his plea, Grantham's counsel expressly indicated to the court that no sentencing agreement with the state existed. The court made no promises at sentencing and instead outlined its sentencing options to Grantham and ordered a PSI.
How, counsel, do we get to the point where the trial judge is saying, I know you're probably under the understanding that you're not going to be going to prison? How does that come up if there was no plea agreement with the state early on? What does the record reflect?
I believe he withdrew the matter was set for sentencing after he had pled guilty, and then there were discussions in chambers about additional allegations that had arose, and he had reviewed the pre-sentence investigation, and he indicated that he was considering community control sanctions, but he was not sure how he was going to sentence, and those additional allegations raised a red flag, and he was possibly going to consider a prison sanction at that point, but he allowed him to withdraw his plea based on those additional allegations. I think is that an answer to your question?
It is. Yes,
Okay.
it is. Thank you.
Okay. So any plea negotiations between Grantham and the state for community control sanctions, which followed his plea withdrawal, yet preceded the ultimate trial, were never approved by the trial court and ultimately failed. After having sat through the jury trial, the trial court had a wealth of information before it to factor into its sentencing decision that it did not have at the time of his initial plea. And the trial court indicated this fact at sentencing. In fact, the trial court heard evidence that Grantham, who was 49 years old at the time of the offenses, solicited 15-year-old KR to engage in sexual activity by sending her text messages of a sexual nature. Evidence at trial also demonstrated that when Grantham knew that the police were about to investigate those sexual offenses, he deleted those text messages, thereby destroying and concealing their existence from the police. As the trial court knew more about Grantham's case, including the circumstances surrounding their events and their victim impact, than it did at the time of the initial guilty plea and subsequent plea negotiations, there were legitimate reasons why the trial court sentenced him more harshly after his trial than it may have done if it accepted his guilty plea. Therefore, the state would submit that Grantham failed to clearly and convincingly demonstrate that the trial court imposed a vindictive sentence. The state would further submit that Grantham's convictions are supported by sufficient evidence. As to Grantham's tampering conviction, he is submitting that the state failed to establish that he deleted the 3 text messages which formed the basis for his importuning charges while knowing that an investigation was in progress or likely to be instituted, because no evidence was presented as to a definitive date as to when the text messages were deleted. Although the detectives in this case could not testify as to a definitive date, Grantham's knowledge that an investigation was in progress or likely to be instituted was properly inferred from circumstantial evidence and the totality of the circumstances. Circumstantial evidence, as we know, carries the same weight as direct evidence. Here, the state presented evidence to show that Grantham sent 3 text messages of a sexual nature to KR late on August 18th into August 19th of 2014. KR then reported the sexual assaults to her aunt on September 8th of 2014. They went to the police that same day. On the way to the police station, KR's aunt called Grantham and warned him of the investigation. Therefore, Grantham knew an official investigation was likely to be instituted at that point. In his interview with detectives, Grantham admitted that he had received a phone call from KR's aunt while she was on her way to the police station regarding the rape allegations and that he was expecting the police. Following the interview with Grantham, Detective Sumter forensically examined Grantham's cell phone. The cell phone was seized and a warrant was subsequently obtained to conduct a search of its contents after Grantham refused to consent to search his phone. This is important because Grantham had offered to let detectives look at his phone during the interview, but evidence at trial showed that any physical evidence of the text messages had already been deleted from Grantham's phone at that point. But the cell phone extraction of the phone recovered deleted text messages and content, which matched the messages on KR's phone, which she had shown police, letter for letter and word for word. When Detective Sumter looked at Grantham's phone itself, he noted that the oldest message on the phone was from September 8, 2014, the day he received a phone call from KR's aunt informing him of the impending rape investigation. The state would submit that based on the totality of these circumstances and the circumstantial evidence presented, viewed in a light most favorable to the state, that there was sufficient evidence to support his tampering conviction. As to the importuning conviction, the state submits that based on the record and Grantham's own admissions to detectives, that there was sufficient evidence to prove that he solicited KR to engage in sexual activity. Here, Grantham claims that the 3 text messages which he sent to KR were not sexual in nature and could have been a reference to something other than a sexual act. At trial, the state offered, as an exhibit, evidence of the 3 text messages between Grantham and KR wherein he solicited sexual activity from her. Detective Homoki, who has years of investigating sexual offenses, also testified to his interview with Grantham and the content of the text messages. Those text messages alarmed Detective Homoki, who noted that the text message appeared to be sexual in nature because Grantham chose to spell the word come in a sexual context. In fact, Grantham confirmed, and he did confirm, that the text messages were sexual in nature after initially lying to detectives regarding the text message and their content. Grantham's story, in fact, changed as his interview with the detectives progressed. He first told investigators that he never sent the messages. When he was then confronted with the specific text messages, he said that the messages were innocent in nature and referred to things such as breakfast, much as he now claims. Finally, after describing 15-year-old KR as a flirt and a tease, he did say that the text messages were sexual in nature. The state would submit that based on Grantham's own admissions and the content of the text messages themselves, there was sufficient evidence presented by the state to prove that Grantham solicited KR to engage in sexual activity. As to the manifest weight argument presented by Grantham, the state would submit that Grantham is essentially recycling his sufficiency of the evidence argument and arguing that there was insufficient evidence on the elements of the offenses and has not maintained an argument separate and apart from his sufficiency argument, and that the court should reject the manifest weight argument on that basis alone. Otherwise, this is not the exceptional case that weighs in favor of a new trial. The credibility of the witnesses is a fact to be determined by the fact finder. And for those reasons, the state would ask that the judgment of the Lorain County Court of Common Pleas be affirmed.
Hearing no questions. Thank you, counsel.
Thank you.
Yes, I just wanted to clarify one thing from what the state said, was that the plea agreement, there was no plea agreement between the state and Mr. Grantham. And the argument is not that the plea agreement was between the state and Mr. Grantham, it was between the court and Mr. Grantham. And the reason that's significant is because the court had felt that probation was appropriate based on the additional charges, and the agreement was, again, between the court and Mr. Grantham. And then that same court, who had apparently had no issue with the probation prior to the jury trial, had then sentenced to a term of incarceration afterwards. So it wasn't as if the state was making the agreement based on, maybe just even evidentiary issues that they foresaw, or others,
So the court doesn't have authority to enter into a plea agreement. It can accept or reject the plea agreement, but it can't enter into a plea agreement. Did the court specifically say, I'm going to accept this plea agreement and sentence you to probation?
The plea, yeah. So at the original plea agreement, there was conversation that the court would be sentencing to probation, and that's even, and again, it wasn't coming from the state, it was coming from the trial court, that it was their agreement or their statement or, enticement in order to plea the first time was a probationary sentence. And then, and that's even further proof down the line when the trial court at the second sentencing had said that, Mr. Grantham was expecting a probationary sentence because there was that agreement. And I think it's important that it was with the court and not with the state, because the court had, and maybe I'm using the word agreement, but there was an indication by the court that there would be a probationary sentence, and then later on, and the point is that the court felt it was appropriate when there was additional charges, and the only thing that had changed was that there was a jury trial and actually a conviction for less charges. And I think that, that's where you can see where the vindictiveness is the changes were actually more favorable with Mr. Grantham, and he received a term of incarceration. For that reason, Mr. Grantham would ask that you reverse the decision of the trial court and remand for further proceedings. Thank you.
You had mentioned that there were 2 text messages. The state mentioned there were 3 text messages. If any one of those text messages could be interpreted as a solicitation, you would agree that that would be sufficient to support a conviction, correct?
Yes.
I have no further questions, Judge Hensel.
Thank you. Thank you both for your presentations today. We will take the matter under advisement. We will issue a written decision, which will be mailed to everyone, as well as posted on our website and the Supreme Court website.